Good day, I'm Professor Charlie Rose, and this is Practice Ready Evidence. Wherever you are, I greet you digitally. In this block, I want to talk about Article 4. I want to continue our discussion about the federal rules of evidence, particularly as it relates to those Article 4 rules that are very much policy-driven. And by that I mean we've created them because there are certain policies or certain behaviors that we want to reward or prevent in the judicial process. And we've created these rules with a specific series of goals in mind. Now, what that means from an evidentiary law perspective is that they can sometimes be counterintuitive, and you have to just look at them and think about them in order for them to make sense. Let's get started. I want to talk first about Federal Rule of Evidence 407, subsequent remedial measures. And this is the sort of rule that usually works best if I put it in context for you with a story. Let's say you're walking down the street where I live, and I've got a giant oak tree, and the oak tree has limbs that hang out over the street. And some of those limbs are not as healthy as they could be. You're walking down the street, the limb falls out of the sky, lands on your head and injures you, and you're in the hospital. And you decide to sue me for not properly maintaining my trees. After the accident occurs, I get up in the tree and I saw out all of the dead limbs. I set them on the side of the road, and I had the city come and haul away the detritus from the tree. At trial, you cannot offer the fact that I trimmed the tree after you were injured to prove that I've been negligent in not trimming the tree previously, to show that there was something defective about my tree or that I needed to set up a warning sign. You can't use it to establish liability because I trimmed it after you were injured. We want to reward, from a societal perspective, those who make society safer. So whenever something happens, giving you notice of a potential danger, and you then take subsequent remedial measures to fix it, the reward that we're going to give you is that we're not going to allow the subsequent remedial measures that you took to be admitted at trial to show consciousness of guilt, negligence previously, or some sort of defect or need to warn. We're going to prevent the jury from knowing that you took that remedial measure. But if you dispute ownership of the item in question, or control of the item in question, or the feasibility of precautionary measures, if you sort of go like, hey man, that's not my problem, then we'll offer the subsequent remedial measures that you took to establish that ownership, to establish that control, to establish that responsibility. So it's not admissible if you're making the environment safer. It is admissible if you try to deny potential responsibility for control of that particular environment. And this is subsequent remedial measures, and we won't admit evidence that is logically relevant to prove a dangerous situation because of the desire to make the community as a whole safer for everyone else. That's a conscious choice that we make under the subsequent remedial measures rule, and it's a ubiquitous rule that often gets tested on the multi-state bar examination because it feels counterintuitive, and you've got to do some reading to identify whether or not an action occurred that is potentially excluded under the first prong of 407, but might be admissible under an alternative theory of admissibility. And it's one of the darlings of the bar examiners. They ask it quite frequently. It's one of those that you only apply if you do that sort of work, but it's there. Now, Federal Rule of Evidence 408, compromise, offers, and negotiations, is a rule that is designed to encourage resolution of civil disputes at the lowest level possible, hopefully not involving the court system. And the way we make it work is that we have set it up so that if you try to negotiate privately your issue with the opposing side, anything that you say in that in that negotiation is not going to be admissible to prove a disputed claim. It's not going to be admissible to impeach you with a prior inconsistent statement if you say something else at trial, or with a contradiction if you say something that contradicts what you said during negotiations. Now, this realizes the fact that we're not always truthful in negotiations when we're trying to get to yes, that we'll say things that are not factually true, but may be emotionally true or emotionally useful to resolve the situation. And we want to encourage that stuff in the civil dispute arena. And the carrot that we give you is that, you can do all that, you can spin whatever story you like, and we're not going to hold you accountable to that story at trial unless we're offering what you said to show a bias or a prejudice, or to negate a contention of undue delay, or to prove an effort to obstruct a criminal investigation or prosecution. Well, what does this means? For example, I could come up to you and say, hey man, I'm so sorry that happened. I am clearly at fault here. I apologize. Let me pay your expenses for the damage to whatever it happens to be. That's a compromise offer in a negotiation. That admission of liability, I'm so sorry this happened, I'm responsible, is not severable or admissible because the admission of liability is part of the negotiation. It's part of the manipulation that we're engaging in to try to get the other side to settle the case. It's not a true admission of liability. And it's not surrounded by the indicia of reliability such that we're willing to admit it. We'll let you say you're sorry when you're not. We'll let you accept responsibility when you don't, when you're trying to drive settlement of a claim prior to trial. And unless you're obstructing a criminal investigation, or you've just got bias and prejudice against one of the sides, or you're trying to delay things, unless you're in those limited categories, what you say during pre-trial negotiations and attempts to settle cases is not going to be admissible at trial. This is a rule that civil trial lawyers need to understand, and understand very well, because you want to make certain that your client doesn't get hoisted on their own petard, that they're not blown up by their own hand grenade if they say one thing during negotiations and say a different thing at trial, because that can be problematic. Federal Rule of Evidence 408 is an interesting rule. It's kind of self-contained, but you can read it in conjunction with Federal Rule of Evidence 409, which is an offer to pay medical and similar expenses. Now, an offer to pay medical expenses and a statement of liability often go hand in hand. I'm so sorry that I hit you with my car. Let me pay for your medical expenses. Now, evidence of furnishing or promising to pay or offering to pay medical, hospital, or similar expenses resulting from such an injury is not admissible to prove liability for the injury. But the statement, I'm so sorry I hit you with my car, followed by, let me pay your medical expenses, the I'm so sorry I hit you with my car is an admission of liability. It's an admission by a party opponent, and it is severable from the offer to pay medical expenses. So a jury could be told that you said that, but never know that you offered to pay the medical expenses. Now, this is interesting because it's different from 408, where we're dealing with the offer to compromise and negotiate. You'll notice in 408, that offer to pay is not admissible. The offer of liability, the admission of liability, is not severable. It's not admissible. Well, what does this mean practically speaking? It means that I should never admit liability and offer to pay medical expenses unless I am aware of pending litigation, because that changes the offer to pay medical and similar expenses into an offer to settle the case or negotiate. And so a timeline becomes really important when I'm dealing with fact patterns that apply to Federal Rule of Evidence 408 and Federal Rule of Evidence 409. And the argument of getting them in one lane or the other can be really important from the standpoint of sorting out how these rules actually apply. Now, because these rules have different impacts from the severance of admissions of liability, and because they are dependent upon whether or not litigation is in place or the possibility of litigation is in place at the time that the statements are made, they are the darling of the National Conference of Bar Examiners. They like to ask questions all the time. They use both Federal Rule of Evidence 408 and 409 in tandem with one another, requiring you to read with specificity the call of the question to be in the right lane. It also has a huge impact on the potential admissibility of statements made if you're going to trial on a liability case. In a civil case, slip and fall, more commonly car accidents where someone admits liability right after the accident occurred. So in all of these instances, you have to be aware of both how 408 and 409 work together. If you're getting ready to take a bar exam, you are by God going to see them again. There's not much doubt about it. And if you're going to be working in the civil arena, particularly if you're involved in car accidents or other types of torts that are similar, you're going to find these rules rising to the top at some point in time. In Florida, our rules are much the same, except we have some additional rules like benevolent gestures, which I won't talk about today, but if you're interested, you should watch one of my other presentations on the Florida Rules of Evidence. So remember, 408 and 409 have to be thought in tandem with one another. Let's take a look now at 4010. At 410. 410 deals with pleas, plea discussions, and related statements. We start with the idea that in both civil and criminal cases, the following is not admissible against the defendant: the withdrawal of a guilty plea, a nolo contendere plea, or statements made under Federal Rules of Civil Procedure 11, or statements made during plea discussions with an attorney having prosecutorial authority, particularly if no subsequent guilty plea, or if a guilty plea is later withdrawn. So the idea is that we want defendants to come to the table to negotiate with both the plaintiffs in civil cases and the prosecutor in criminal cases, where possible, to resolve issues. And so the carrot that we give you is that if you do that and you later decide, I don't want to take the deal, we are not going to admit anything that you said to the prosecutor or to the plaintiff's attorney to establish liability, either criminal or civil. We're not going to let it in. Now, there is an exception that applies to plea discussions and related statements. If part of what you've said previously is admitted by you at trial, and the rule of completeness would normally require that the other part of what you said be admitted so the jury can understand the context of the statement, we might pierce the protection of Federal Rule of Evidence 410. If you're on trial for perjury or false statement, and it's offered to prove your guilt, and that earlier statement was under oath, and your counsel were present, it's generally going to be allowed there. The gray area is impeachment, where you take the stand and you say something that directly contradicts an assertion that you made to the prosecution. Now, in some instances, that is going to be admissible, and in other instances, it's not. That particular rule, that particular exception, actually bumps up against the rules of exclusion under constitutional law for investigations and admissibility of otherwise inadmissible statements or pieces of evidence. If you're interested in that, I would refer you to some of the lectures that I produced on federal criminal procedure, particularly the block of instruction talking about the exclusionary rule and how the exclusionary rule impacts the ability to impeach with statements that were previously excluded. I talk about that there. It's a little bit beyond the pale for this particular block of instruction. Now, the last rule that I want to talk about in this block is Federal Rule of Evidence 411. Federal Rule of Evidence 411 deals with liability insurance. And the idea behind liability insurance is that we want to incentivize people to have liability insurance. And the incentive that we're going to give you is that we're not going to allow the existence of the liability insurance to be given to the jury to prove that you were negligent or to prove that you acted wrongfully. We don't want the jury deciding liability knowing that you have insurance, because that might impact not only their decision on liability, but their decision on the awarding of an appropriate judgment. And either one would not be the right way from a policy perspective for juries to proceed. And because it wouldn't be, we're very careful with that. On the other hand, Federal Rule of Evidence 411 is admissible to prove your bias or prejudice, agency, ownership, and control. This is now a theme that we've seen running through 407, 408, 409, 410, and 411. All of these rules are designed to limit for us to some degree the amount of evidence that we're going to allow to be admitted. In each of these instances, what we're playing with is a balancing test. It's a balancing test between the desire to incentivize behavior on the part of the defendant and the hopes that by doing so we avoid litigation. The backside of that is that when that happens, it all works out. When it doesn't happen, however, we're not going to let this evidence in unless you're using it for some other purpose, unless there was some attempt to game the system through the negotiation or through the discussion or through the offer to plead. In those instances, we're going to look at it carefully. So as you think about these rules that we've discussed today, consider them from that balancing test perspective. Make sure you understand where those tests are, where the tripwires are, what makes it work, what makes it not work. If you do, I think you'll be in good shape. Till next time, I'm Charlie Rose, and this is Practice Ready Evidence.